Hi, everyone. Thank you so much for joining us for our final webinar in our 5-part webinar series. So you thought you knew health privacy. Wow, what a journey we've been on thus far. This is our 5th month, part 5. Finally, you're going to hear kind of a summation of what we've been talking about, what we think the future of healthcare privacy is going to look like. And we're going to give you a few takeaways from us that we've seen and some takeaways from the FTC that were just very recently released. Want to make sure everything that you're hearing is on the cusp, fresh off the presses. And here we go. Just a couple disclaimers, as always, before we get started. Attending and listening to this webinar does not make you a Nelson Hardeman client. This webinar is provided for educational purposes only and is not offered as and is not to be relied upon as legal advice. The things we are going to be talking about here might be more California centric because California is on the cusp many of the state privacy laws, and we are located in California. If you're considering what to do with the information presented in this webinar as to a specific situation you might be dealing with, please call a professional healthcare attorney to help you out. We here at Nelson Hardeman are always ready and willing to help, no obligation. As always, I am Adela Katz. I'm an attorney here at Nelson Hardeman. Sitting with me is our wonderful founding and managing partner, Harry Nelson.
Great to be with everybody today.
Just a brief agenda before we get started. We're going to give you a quick recap of everything we've discussed up to this point, go through our journey, and then we're going to go through some short-term and long-term considerations for all the different entities and organizations, provider groups that we've been talking about this whole time, and then end up with some final takeaways from us and from the FTC.
And I just want to say before we get started that part of our goal in this entire series has been to sort of provide an overview of how much health privacy is changing very quickly in front of our eyes. We've been trying to do that, and part of the goal of today is sort of where to go from here, because those changes are going to keep coming. Yeah. So we hope that that's what the takeaway from today ultimately is, some sense of how to deal with a rapidly changing health privacy environment.
Definitely. So this big, complicated, colorful slide, something that we've been showing you again and again and again. We started this series by showing you the history of healthcare privacy, how it's evolved, and really the wild and significant changes that have come down the pipeline in the last 5-10 years. We've gone through the significance of 42 CFR Part 2 in the 1970s, how that law started the charge in healthcare privacy, focusing on substance use disorder providers, protecting that information, protecting consumers and clients, patients from stigma that came from releasing confidential health information. That led us into California, as always, leading the charge with its CMIA in the 1980s. And of course, in 1996, the release and the beginning of the HIPAA revolution, which again led the charge for federal healthcare privacy, but has never really evolved until now. This slide, as always, identified different changes that came down the pipeline, especially in the last few years, with states coming in to fill in the gaps that the federal government just wasn't filling, as technology has evolved super rapidly, and as consumer information has been collected in droves like we've never seen before.
And just to point out on the slide, we're really talking about a history that goes back 48 years, right? We're not quite at the 50th anniversary of the original sort of grandmother of all health privacy laws that we started talking about in this series, 42 CFR Part 2. And it's really breathtaking, as Adela mentioned. Really, the story of health privacy laws and regulations is really a story of how privacy itself has evolved as we've moved in healthcare from a paper records era to a digital era, and one in which the ability to be tracked, followed, identified, and commoditized online has really created a whole new understanding of the risks and the need to protect privacy. So it's really amazing if you think about it, how far we've come, and it's fascinating to look at these laws and the interplay between them, and the way that the gaps in one law have led to changes in a new law, and how it's gotten us to the current moment.
Definitely. And as we've seen just this year, which we've talked about previously, we'll talk about later on in this very webinar, for the first time in history, the FTC has really jumped into the healthcare privacy space. It actually released its own health breach notification rule at the same time that the HIPAA breach notification rule was released, stayed dormant for almost 15 years. And for the first time, a different part of the federal government has really taken notice of the desperate need that we have now to protect consumer information that's being collected in ways we've never seen before. So we just wanted to recap some of the gaps we've seen in healthcare privacy thus far.
Yeah, and a lot of this was stuff we covered in our earlier webinars. Really a significant piece. You can't talk about health privacy without making HIPAA a sort of centerpiece, even though HIPAA comes into the story relatively late, right? We're already into in 1996, so 20 years into the privacy story. But much of the current activity we've argued in this webinar series is really about the growing awareness of the limited reach of HIPAA. And as I mentioned a minute ago, the growing awareness that technology is a sponge for consumer data, and really in a staggering way that's changed dramatically even in the digital era. The way that we are able to be geolocated and marked as we travel around the web and identified by our searches, by all of our movements, and the extent to which those really erode privacy. The worry, part of the story here is very clearly a worry about big tech and the way that the power has been so concentrated in companies like Google and Facebook and other social media players, and the way that those companies really have enormous access to your information and really destroy or erode your privacy by virtue of their ability to track your digital health footprint. We talked in this series about reproductive health as a particular driving issue that it's unmistakable to see that federal policy and the FTC action is very much concerned about the way that health privacy erosion has really led to vulnerability on reproductive health access and protection, and in the way that issue and the repeal of Roe v. Wade has played into this. And finally, we've talked about how the FTC, the Federal Trade Commission, has really had a wake-up call at the federal level that parallels this development in the states, led by California, the California Consumer Privacy Act, and a growing list of states which have really sort of tried to take a European paradigm that is much more concerned about privacy and expanding what privacy rights mean. And when you look at all these things together, these are really, I think this explains this new era that we're in. And it should give you a sense of what a profoundly different point we're living through than where we were a decade ago, let alone in 1996 when HIPAA came into the picture.
Right, which didn't even consider addressing any of the types of information that are being collected right now. For example, like any kind of geolocation information.
Yeah, and I think, by the way, one of the things we really want to stress is even for we're going to talk about the different healthcare privacy requirements and implications for different kinds of companies, but even for traditional healthcare providers, one of the takeaways we hope out of this webinar is that it's not enough to be focused on HIPAA. HIPAA may answer the questions about how you handle data, protected health information within the operational flow of your organization for purposes of treating patients, getting paid, and your administrative purposes, but it does not address how you market to patients. And it also doesn't address how you notify patients about and consumers who visit your website about their privacy rights. So there's all kinds of places in which HIPAA is only the beginning and not the end of the story, even for traditional healthcare providers.
And over the last 5 years, and we've shown this graphic before, but over the last really 5 years, we've seen a huge shift in states trying to jump in the healthcare privacy game, states trying to protect their individual consumers, their state residents, because they recognize that the federal government is just not cutting it. So California first passed the CCPA in 2018, effective 2020, after seeing the European Union pass the GDPR, as we discussed in our previous webinar, and the success and the aggressive tactics that the European Union took to protect its consumers' privacy. from 2020 on to 2026, just a couple of years from now, 10 states have passed and are going to be, and some states, some states' laws are already effective, and some are going to be effective up until 2026. They've enacted comprehensive privacy schemes. That's not to say that other limited and more narrowed state privacy laws protecting health information don't exist, because they certainly do, as we've seen with the CMA, even as far back as 1981 in California. We've seen this huge shift in states passing comprehensive privacy schemes to protect information that direct-to-consumer companies are now collecting that don't fall within the purview of HIPAA. So states are trying to address these gaps very, very quickly, and are doing so in ways that we've never seen before, and are targeting companies that have never been targeted before and that have kind of fallen under the radar for the past decade or so. We've also seen this huge wave of class action lawsuits against traditional covered entities, healthcare systems, hospital systems that have been kind of falling under the purview of different kinds of state privacy laws, not specifically under laws like the CCPA, but different kind of state laws, tortious actions that are tackling these hospital systems marketing practices, because they are acting and they are marketing their practices, sharing, selling consumer information like lay entities in ways that certainly violate consumer rights and are not taking into account the new protections that are coming down the pipeline.
This, by the way, this is a really important point. We have not, frankly, our perception is that the media, the legal profession has not been doing a particularly good job of telling this story, partly because it's a news story and a lot of these cases haven't been decided yet. But it's really interesting as lawyers dealing with health compliance, healthcare compliance generally, and health privacy compliance. We often, it's easy to fall into the trap of thinking that all we need to do is worry about, are you meeting the government requirements and is the government taking action? And a lot of the story in health privacy has been this belief that CMS, the Center for Medicare and Medicaid Services, and the Department of Health and Human Services, which oversee HIPAA, have been fairly light touch on most kinds of violations, and so that's all you need to worry about. And the real story in health privacy, as in so many other areas, is that if you want to really understand your risk profile, you need to be paying attention to plaintiff class action lawyers, because they are the leading edge of the most aggressive enforcers, private enforcers, who are seeking to find potential liability connected to noncompliance. And as Adela mentioned, they're using all kinds of theories, and there's an enormous amount of energy and creativity pent up in these cases. And the list, we can guarantee you that the list that is on this slide is just the tip of the iceberg of who will ultimately be subject to these kind of cases. This is a story that's not going away. And all of these new laws are really just opening up new theories that plaintiff lawyers can use in class actions against a broader and broader group of healthcare providers. And I would urge people to be paying attention to this. And frankly, it's been surprising to me how slow our colleagues and the media have been to really cover this emerging story.
And a very significant and definitely untouched and not discussed issue is that a lot of these comprehensive state privacy schemes, let's take California again, right? California, the CCPA, CPRA is leading the charge. All of these comprehensive state privacy schemes do have significant limitations, one of which is the trigger, right? The trigger, how are you even subject to this state privacy law? Who is subject to the CCPA? Not every organization, not every kind of provider, company, et cetera, is subject to the CCPA. The biggest triggers, you have to be a for-profit company. However, the new rules, the new revisions that were released by the CPRA very recently actually said that if nonprofit companies, at a certain size, assuming they meet the other triggers, have over a certain amount of annual revenue, if they are acting like for-profit companies, if they are seeking, if they have profit-seeking motives, if they are marketing their information like other direct-to-consumer companies, using these meta pixels on their websites, sharing and selling consumer information to find consumer lookalikes, they may very well be subject to these comprehensive state privacy schemes. And that we predict is going to be maybe another huge tactic that these class action lawyers are going to be using in the near future. We haven't seen it yet, but we think that that might be coming down the pipeline. And that is something that large providers have to be wary of right now.
And the other thing I think is important to add to that is that even with existing laws that haven't been used previously in these ways, plaintiff class action lawyers are picking up on evolving social attitudes that judges and juries have, and they're taking their shots specifically because this is a moment where clearly plaintiff class action lawyers believe that judges and juries are ready to start holding people accountable and to be bothered by things that might not have been particularly concerning 10, 20 years ago. So I think that it's really a combination of these new laws and it's old laws that are being repurposed to harness social attitudes and concern about privacy violations.
So now that we've given you kind of a quick recap, we're going to talk about where we believe the future of healthcare privacy is headed. What do different provider groups, entities, organizations have to look out for in the short term and in the long term? And before we dive in, we are going to give you a few new updates that we've seen just a couple weeks ago.
Yeah, and it's amazing, by the way, that's just, if you want the best evidence that how quickly things are moving is even as we tried to sum up in this webinar, what we've been talking about for the last couple of months, there's constantly new stuff coming down. And there's this joint letter from the FTC and Department of Health and Human Services that Adele's going to talk about. There's a new enforcement action even now, and we felt like it would not be responsible to just sum up without giving you the latest and greatest.
So literally 2 days after our last webinar, 2 days, wild, 2 days after our last webinar, the FTC and the Office for Civil Rights, the OCR, which is the entity of the federal government that kind of governs HIPAA, HIPAA breach notification rule. It receives all kinds of complaints and takes action against providers and entities. They sent a joint letter to approximately 130 different kinds of healthcare companies, telehealth providers, hospital systems, et cetera, basically saying, we are alerting you to the risks of implementing tracking technologies on your websites. They specifically mentioned the Metapixel and Google Analytics, which is what all of these FTC actions have been targeting this whole time with direct-to-consumer companies. And the primary message was, take this letter to heart, reevaluate your current privacy practices internally and externally, right? What you're showing to the public, what you're putting on your website, how you're marketing yourself, how you're sharing and selling information, and stop using tracking technologies.
What's really interesting, by the way, is we've talked in this webinar, in the previous webinars, about these two agencies separately, as if they were completely two different domains.
Right.
Health and Human Services dealing with HIPAA, FTC dealing with FTC Act privacy protections. And you can see very clearly these two agencies are trying to send a message to the healthcare community.
So significant that all of the FTC actions that we've seen in the last, let's say 2 years, but more significantly in the last 6 to 8 months, have all been targeting direct-to-consumer healthcare companies, right? So lay entities. And the fact that the FTC and OCR sent a joint letter specifically to healthcare providers under the purview of HIPAA is very, very significant, because it tells us that perhaps what we'll see down the pipeline is the FTC and OCR jointly going against and filing suit against healthcare companies, similar to and probably parallel to the class action suits we were just talking about.
Yeah, really, this is important, and it's yet another sign of which way the wind is blowing on these issues.
And how much care you have to take as healthcare providers, as lay entities collecting healthcare information, to be compliant with, the rules of HIPAA and the rules of the FTC, right? You have to make sure that everything you're putting out that's public facing has to, pass muster of the Section 5 of the FTC Act, cannot be deceptive or unfair to consumers. Also now has to pass muster of the health breach notification rule, which we'll talk about in a second, which the FTC has decided to wield twice already this year.
So we do have a new enforcement case, Vitagene, previously known as One Health IO. This was a case filed in June by the FTC. And what's interesting in this case is Vitagene or One Health was they were a DNA like genomic testing company. And the accusation is that they left sensitive genetic and health data unsecured, that they lied to consumers, that they deceived consumers about their ability to have their data deleted. They suggested that that possibility was out there when it wasn't. And they changed their privacy policy retroactively without adequately notifying and obtaining consent from consumers whose data the company had already collected. So, this is a fascinating case. We're starting to see an expansion of the kind of things that companies can get in trouble for. It's a little funny that we're going to see more. One of the challenges of trying to give compliance advice and write about compliance is there's constantly new stuff coming down, and as soon as we end this webinar, it'll be out of date in some sense. But this case is significant, I think, for expanding the kind of complaints that the FTC is making about privacy practices.
Yeah, because the kinds of allegations, the kind of complaints that we've seen so far, yes, the FTC has built the health reach notification rule, but primarily it's been focusing on companies being unfair or deceiving consumers by lying to them, by saying they're not sharing information when they are, et cetera, et cetera. And this is the first time we've seen that a company has been hit by actually changing its privacy policy retroactively. And this just tells us it's very, very hard to anticipate what to advise to our clients, to you all sitting out there. I mean, we can.
Yeah, and I want to say, for a lot of clients, the privacy policy was sort of an afterthought. A lot of times companies build websites and they say, oh, I can't tell you how many clients have said to us over the years, oh, I found a great privacy policy on this other competitor's website or on someplace else. And they're saying, well, we don't want to spend a lot of money on the privacy policy. And it's been something quite minimal. And what this case really highlights is your privacy policy matters, and it matters how you adjust it and change it. It's not just some little, afterthought on the bottom of your website or your app. It is a really important piece of how you explain to consumers how you're handling their data. And if you're going to change it, you better get their permission. And I think this should be a wake-up call that every company out there needs to be making sure that its privacy policy aligns with its actual practices, and if it's making changes, that it's actually notifying consumers appropriately.
So let's talk about the different kinds of organizations, entities, providers we've been talking about throughout our series. I'm going to talk about some short-term considerations that all of these different kinds of entities should consider moving forward. Related to the information we were just talking about. So as to healthcare providers, which are covered entities, business associates under the purview of HIPAA that have to comply with the HIPAA rules, we wanted to really specify that it's absolutely critical that your marketing practices, first and foremost, that are externally facing on your website, on any kind of mobile app, are using client data in a way that complies with any kind of state rules that are coming out, as well as HIPAA, as well as considerations that the FTC has been pushing out. There's no use in pulling a stock privacy policy from the internet. Everything must be customized. You can't just talk the talk anymore. You have to walk the walk when it comes to putting out external facing documents. Everything that you're writing in your privacy policy, your terms and conditions, has to actually take into account your real practices. Reflecting how you're going to collect information, how you store information, right? Especially for covered entities that have consumer-facing websites. There's certain information on like fill-in forms, for example, that's considered PHI versus other information that you're collecting that may not be PHI. How are you storing and protecting the PHI? How are you storing and protecting the other types of information? That should be disclosed. How you're sharing, who you're sharing information to, how and who you're selling information to, any kind of third-party advertisers, what they're going to be doing with the information, what you're seeking to do with consumer information in general.
By the way, we've had a couple of clients who have been working with outside vendors and contractors to handle these services, and it should be, at the risk of saying the obvious, it doesn't matter whether you're handling your marketing functions totally internally or whether you're working with outside entities. That's a great point. These rules apply and are relevant. You need to ask the right questions, even if you're dealing with outside vendors.
And just a few other considerations. Any provider who thinks that HIPAA is the only privacy scheme that you have to comply with, you should disabuse yourself of that notion entirely. As we've been emphasizing over and over and over again, if you have an online presence and if you're marketing your services to consumers, there's so many other considerations that you have to take into account. HIPAA is not good enough anymore. HIPAA may be good enough for your internal policies and procedures, maybe internal employee trainings, but anything that's consumer facing, anything that's external and public has to comply with all of these different kinds of laws. Oh, and one more note, as we've talked about a couple webinars ago, 2023 is really the first time in many years that we're seeing significant changes for HIPAA and 42 CFR Part 2 come down the pipeline. So even if you're amending your privacy policy right now, maybe later this year, there are going to be new rules that will require you to amend your privacy policy once again. So with having a privacy policy, having your terms and conditions on your website is an ongoing activity, something you always have to be mindful of, and something that is going to be ever changing. So don't think that just because you have one beautiful privacy policy, that's going to be the be all end all. It's an ongoing process for sure.
One thing that I think we can say, by the way, having been dealing with HIPAA for so many years, I literally think there's been 25 years where we've said, this is the year where enforcement is going to start. I think this is a really important moment coming up. I think, 42 CFR Part 2 is really fascinating. We thought it was really important to take the story back to the 1970s because that was the first law. But I think we've been seeing this strange situation where 42 CFR Part 2 was largely never enforced. And then only in the last decade did it start to get more and more attention, particularly as the Affordable Care Act really transformed behavioral health and substance abuse disorder treatment became such a bigger feature of the healthcare landscape. But I think this really will be the year where we start to see 42 CFR Part 2 really have much more practical meaning. Until now, a lot of times you'll see people hold it up as an argument why they don't have to disclose data, but it's been very, very rare to see the government actually try to enforce it. And I think that as we finally start to see HIPAA and 42 CFR Part 2 come into alignment, it will become much more real with more government enforcement.
Definitely. And as to direct-to-consumer healthcare companies, as we've been talking about so often throughout this series and so much right now, direct-to-consumer companies in general, and those that are collecting consumer healthcare information like GoodRx, BetterHelp that we've seen in the news, even Apple Health, Samsung Health, any kind of weight loss mobile apps, and any kind of period tracking apps that we've seen very frequently targeted by the FTC very recently. They all have to comply with the FTC's laws, both Section 5 of the FTC Act, the Health Breach Notification Rule, as we've seen the FTC enforce twice already, and also state privacy laws. Right, again, there are significant limitations to each of those different kinds of schemes, especially state privacy rules. But as the FTC continues to make examples out of these very large companies, we're going to see more and more that companies are going to have to come into compliance with all three of these different types of privacy schemes.
And I think it's important here to say the health breach notification has been the single most important compliance obligation within HIPAA, right? If there was one thing that would get you in trouble, it was not being ready to be able to detect a health breach, not responding appropriately, and doing the analysis to determine if a breach was potentially reportable. And just that was, if there was one singular risk that I would say we've seen hitting healthcare providers, that was the biggest. And I would say this is the single biggest health privacy takeaway for consumer companies, for all the health and wellness direct-to-consumer businesses that don't think of themselves as healthcare companies. You must absolutely have policies and procedures. You have to be ready to show that you were in a position to identify a health breach and to take the appropriate actions in the aftermath.
Yeah, both covered entities and their business associates, right? Which was a new change in 2013 when the OCR and HHS said, hey, business associates, you are now going to be just as liable and just as much at risk of being hit by a hefty penalty by the OCR for failing to comply with HIPAA. So, what does that mean for direct to consumer companies now? Does that mean that because the FTC has started wielding its, new sword, the health breach notification rule, that now all major, large, healthcare direct to consumer companies have to now have internal policies and procedures for the health breach notification rule, develop employee trainings, on an annual basis? Like, we have no idea what that's going to look like. Has the FTC said anything in that respect? Not really. I mean, the FTC has given us some internal guidance, a lot of which was released a couple weeks ago, which we'll talk about at the end of this webinar, but have they said anything about internal compliance? Not really, but probably something that's going to be coming down the pipeline. We'll see if the FTC is going to amend the health breach notification rule and impose those kinds of requirements on direct-to-consumer companies. But, right now we can only anticipate what's coming down the pipeline and, what's going to bring all these direct-to-consumer companies into compliance. Perhaps the best way of moving forward is to draft internal policies and procedures to make sure that both internally and externally, these direct-to-consumer companies are covered. But who knows what's coming down the pipeline.
No, and we'll get more to our takeaways, but I personally, I'm advocating that you need to be proactive. It's not enough. This is not a place where you can sort of just say, I'm going to do the absolute minimum necessary, right? There's a lot of compelling reasons here to go above and beyond because of the way that things are in flux. We'll talk more about that.
Just a quick recap. Who does the health breach notification rule, the FTC's health breach notification rule, apply to? So basically it applies to all direct-to-consumer companies that are collecting consumer health information that are not considered covered entities or business associates. What are covered entities? Covered entities are healthcare providers, which can be organizations or individuals or health plans, healthcare clearinghouses that are engaging in HIPAA transactions, right? They're submitting and transmitting electronic protected health information online and submitting claims to insurances. Business associates are vendors like EMR companies, like billing companies that work directly with covered entities. So mirror that to lay entities. So any kind of direct-to-consumer company, I keep picking on GoodRx and BetterHelp, but the companies that we've seen in the news, for many months this year that are sort of doing similar things. They are collecting consumer information and they may also be billing insurances. They may be taking information from them, but because they're not considered covered entities, they're not subject to HIPAA. They're completely covered under an entirely different scheme. And their vendors that they work with are also subject to the health breach notification rule. As we discussed, it's any company that's collecting consumer information. The terminology under the health breach notification rule is different, but basically the requirements are the same, as are the requirements for analyzing breaches, performing risk assessments, and reporting breaches. The difference is obviously is that the breaches or any kind of unauthorized access are reported to a different entity, the FTC, not to the OCR, but presumably the penalties are going to be similar, and really they're only going to be increasing at this point because we've seen the FTC take significant action this year. And the third category of interesting entities that we wanted to talk about that may be subject to both HIPAA and the FTC's breach notification rule are business associates. So any kind of vendors, and the FTC has released limited guidance about this, but any kind of vendor that's performing services and touching consumer health information that works with both covered entities and that works with lay direct-to-consumer entities that are collecting consumer health information, they may be subject to both schemes, which means that they need two sets of internal policies and procedures to comply with, that they need to be wary of two sets of compliance schemes. I mean, we don't know what it's going to look like for this kind of third category of of entities, but very interesting to see what comes down the pipeline and whether the FTC will actually go after these kinds of vendors as well. So where are we headed? Let's talk about some long-term considerations related to protected health information and for security that the FTC has specifically released. So literally just a couple weeks ago on July 25th, the FTC released a very endearingly titled internal guidance called a baker's dozen, takeaways from FTC cases. The FTC decided to release information that hopefully is helpful to direct-to-consumer companies, and summarize most of the considerations that they expect all these entities to take into account and move forward with in expanding and improving their compliance. So first of all, they want companies to understand the breadth of health information. So as we've been talking about, the laws that were passed in the 70s and the 90s, they didn't take into account the kind of health information that's being collected today. So what's included in the definition of health information? Well, now it includes geolocation information, it includes biometric information, any kind of retina scans, fingerprints. I was reading the other day something about palm scans now. I mean, and all kinds of DNA genetic information is collected. So all these companies have to understand exactly the type of health information that's being collected, and that it's subject to all of these new laws. It's not limited to just name, address, health insurance ID, bank account information, social security number. The definition has certainly been expanded. Their obligation to protect the privacy of the health information is a given. Again, they're emphasizing the fact that companies should not use these hidden tracking technologies and embedding them into their website to find lookalike consumers. Consumer information shouldn't be shared improperly and shouldn't be received improperly. And if you're going to share information in a certain way or receive it, you've got to disclose it publicly to your consumers.
And just to go a little bit deeper on what's really going on, when you read this, it's impossible not to come away with the message that the FTC believes that the industry largely devalues, doesn't take seriously privacy concerns, that there's a lot of say this, but do that.
Right.
And really not a sort of an internal inherent valuing of the importance of privacy, taking privacy seriously and privacy compliance as part of your brand. And they are very clearly trying to send a message that era is over, right? That for every company, your brand depends on your integrity with respect to what you say and what you do with respect to health data.
Definitely. And they release specific compliance guidance, tips, and tricks for HIPAA covered entities specifically. They really want to emphasize that just using the terms HIPAA compliant, HIPAA secure, putting some kind of fake seal or certification on your website and alerting the public, don't worry, we're HIPAA secure, etc. That's not good enough. Yeah,
this is really important, by the way. We talked in some of our previous webinar about the third-party certifications that are out there that have gained industry recognition, things like High Trust and SOC 2. But it's very, very important. This is what goes back to the beginning of HIPAA. We've had clients asking us, can we use terms like HIPAA compliant? And there was an era where that seemed like a fairly harmless, thing that people would do. It's very clear that era is over, and that making these kind of claims is putting you at risk for simply being perceived as dishonest in terms of how you're communicating.
Definitely. And they also made a big point of saying that hidden euphemisms or any kind of enigmatic references about collecting consumer information, sharing it, simply putting a statement like, we share your information with third parties, or we do not share your information with third parties. That's not good enough anymore. These agencies and especially the FTC is clearly saying, by leaving it vague, by omitting specific information, you are deceiving consumers, and omission is, makes you just as culpable as commission, right? So you want to make sure that, again, you're not just talking the talk, you're walking the walk. Everything you're putting into your privacy policies is actually what you're doing in real life. And they're including different kinds of information that should comply with this. They made a big point of specifying that biometric data, everything that we just talked about, is also subject to all of these rules. And they very specifically pointed out that reproductive information should be, and this is their words, should be protected from prying eyes. Very interesting that they released such language publicly, because they're clearly sending a message to the industry.
Yeah, it's very clear that this whole issue, as we've said, is threading through and is very much a driving force in driving the government's concern, and I think public attitudes around this. And just in general, with regard to all of these FTC lessons, what's striking to me is, we always say that the three values underlying all compliance are transparency, right? Like being really clear about what's happening, accountability, taking responsibility for it, and integrity, being honest about it. And what we're seeing is that those values are really being applied to how you communicate to the public and to individuals, to consumers. And really, like, again, just a clear sense that the FTC does not believe the industry is getting it right in terms of hitting those values.
Right. And just generally, the FTC has released some lessons about how to improve your security practices and how any company, especially direct-to-consumer companies, should evaluate its security, protecting any kind of health information that's being collected. Require secure passwords internally and also externally for your consumers, because the prevalence of hacking is very heavy out there right now. Certain tips and tricks on how to store sensitive personal information securely, as we've talked about, for any kind of covered entity that's collecting this information, any kind of direct-to-consumer company that's collecting information. Storing and securing health information is very different than storing and securing different kinds of information. Access to networks should be secure, etc. They're just emphasizing how to improve security practices.
And one of the things, we talked about this on one of our prior webinars, but I think it's interesting to see here that when we talk about health privacy, a lot of health privacy comes down to basic information in protecting information generally, right? What we talked earlier about SOC 2, which is the kind of broadest single standard that people are holding to, isn't a healthcare standard, right? It's about general good data security practices and controls that organizations need to have in place if they're going to receive this certification. And what I would say in terms of getting this message from the FTC is that the challenge is that a lot of businesses don't only feel the pressure to get into compliance or get these outside certifications and hit these standards when they're at a moment of truth, where they're looking for an investment from institutional investors, or they're at a moment when somebody, an acquirer, is like really testing and kicking the tires on their health privacy policies. And the FTC is making it very clear that on day one of your new venture, you need to be paying attention to having good fundamental practices and controls around data, so that you're not just setting up a problem as you move forward. It's almost ironic. We're not coming to the end to talk about healthcare. We're talking about basic data security control.
Right. And another point I wanted to make is that all of these health privacy schemes, the health breach notification rule from the FTC, the HIPAA breach notification rule, when they talk about security measures, they always use the word reasonable, right? But I think it's very clear that the definition of reasonableness has not only changed, but is constantly evolving with different types of cybersecurity standards that are needed to really secure information in today's day. So now a few takeaways of our own.
So, okay, so this is a really important point that I just, I want to make here to tie into your last comment, Adela. What do you do in an environment where everything is in flux? Because what we hope you've taken away from this webinar series is that health privacy generally, but health privacy for our purposes, is in a moment of incredible flux, as is health privacy enforcement. And so at a high level, the one of the questions that always comes up, and one of the real lessons of doing this work for a long time, is that in this kind of environment, it is a mistake just to ask the question, what's the minimum that I need to do? The real question is, where is this trajectory heading, and what practices do I have to be putting in place today to be prepared for 6 months from now, or a year from now, or 2 or 3 years from now, when the standard is different than it is today? So in a moment when the tide is rising on what the laws are, what the expectations are, and what the enforcement from the government will be, it's absolutely critical that you not just chart a course for getting the minimum done today, that you actually think about the broader question of, is that going to be enough for a year from now or 3 years from now? And I can't tell you how many times I have seen a healthcare compliance disaster devolve down to this question. That is, that the lawyers took a narrow view, or the leadership took a narrow view and said, no, we're doing everything okay today. And they weren't paying attention to how attitudes were shifting, how enforcement was shifting, and practices that seemed reasonable in 2010 looked unreasonable by 2015. Think about how many areas of our society have just shifted dramatically. You see it in the Me Too discussion, right? Practices that didn't merit investigation, let alone action, all of a sudden were completely intolerable. And I would encourage people to take the same approach here. We are clearly in a moment when things are moving, and it's not enough just to say, what do I need to do today? It is really a moment when you have to say, where do I need to be today so that I'm not in danger over the next few years as this continues to evolve, and as this responsibility gets to be a more and more serious things, not only in terms of government enforcement, but in terms of private parties, in terms of public attitudes, in terms of my brand. And that is the kind of thinking that will keep companies safe, keep leadership safe, and prevent disasters. And the opposite, I can't tell you how many horror stories we've seen unfold where somebody's decision was totally defensible in year one, but by year 3 or year 4, it looked like, what was this person thinking? So the extent to which your organization's brand is tied to your compliance and privacy is clearly is in flux also, right? That's changing. Your brand and your privacy compliance are much more closely tied today than they were 5 years ago, and they will be more tied 5 years from now than they are today. And every company should be embedding ongoing processes to evaluate both internal and external efficacy, right? To see how you're doing, what the risks are of your existing privacy programs, right? This is really more, if there was one central point that I hope people take away from this webinar series, it is this one, right? This is an absolutely critical moment to take stock and to protect yourself, because we are just at, we're at the very beginning. I was going to use a baseball analogy and say we're in the first inning. And I don't know whether what we're in, but we're early in this game. And my prediction is that 5 years forward, we will see a much more mature sense of privacy expectations that is more strict, more robust than today, and on a lower and lower level of tolerance from the government, from plaintiff lawyers, from the public. So this is something to be focusing on today so that you're ready for what's coming.
And to that point, the window of time to get into compliance is getting shorter, especially if you're a large company, especially if you're a direct-to-consumer company collecting consumer health information. Obviously, much depends on where you are and the current size of your company, right? Whether you meet the triggers to even be subject to a lot of these comprehensive state privacy laws, or to be within the purview of the FTC. The FTC seems to be targeting companies that are large, collecting a lot of consumer health information, and companies that they want to make an example out of to warn the rest of the industry what not to do and how to get into compliance quickly. Ultimately, the intersection of health, privacy, compliance, and actual security practices and controls is very critically intertwined. Privacy is clearly no longer being ignored, nor is it being pushed to the side, and clearly the federal government is stepping up.
So we were talking about this a couple of days ago, and I used the phrase "nature abhors a vacuum." I think when we think about what is happening in privacy today, I think it's useful to understand that in many ways the passive approach, the sort of light touch enforcement approach that was in place with regard to HIPAA really is the reason that we've seen this filling of the void by both states with all these consumer privacy laws, by the FTC, and that's going to be a continuing process, right? So every place where it seems that there might not be a problem and there might be leeway is a place that will eventually be filled. And the major changes that we're that we're seeing are really a kind of a collective reaction to this weak period of privacy that previously existed, and that is a bygone era. So, I think it's very interesting. I spent a long time kind of a little bit bored by HIPAA compliance, because HIPAA enforcement was fairly static. It was really, privacy wasn't that interesting of a place as a lawyer to be, right? It was pretty basic. You had to have some basic, compliance pieces in place, but they weren't changing. And that is just not where we are today. The concerns are getting much more serious. They are evolving, and the technology that's creating risks is evolving faster and faster, right? We're only a couple months into the spread of ChatGPT and these AI technologies. And if you think that we've kind of arrived at the moment and everything's going to slow down from here, I would really encourage people to think again. We are at a time when the risks to your privacy are accelerating, and so too the response is going to continue to accelerate.
So, I think the big question on everyone's mind is there anything that we predict is going to come down the pipeline in the near future? I think we've discussed a lot of our concerns thus far, but as Harry just mentioned, I think with the rise of AI and different types of information, different ways that information is being collected, I think there's going to be significantly more enforcement from different kinds of agencies. The combined effort of multiple agencies, clearly, as we're already seeing, as well as perhaps the correction of these limitations within state privacy schemes. Perhaps they're going to lower their thresholds and open up liability to different kinds of companies, to smaller companies, open the doors to nonprofits like these big healthcare systems to be subject to different kinds of state privacy laws. So a lot coming down the pipeline. This is not a moment to be stagnant or to sit and relax. This is an ongoing process, ongoing changes coming down the pipeline. Hopefully, we'll be able to bring you even more information in new privacy series we may have.
Yeah, we're hoping to. Our plan is to actually put together resources and lessons into a book form that's going to be forthcoming, covering a lot of this material, and also sort of trying to give you practical tools to take back to your organization. And so that's certainly one thing we wanted to bring to your attention. We just had a question about the recent data breach and ransomware attack at Prospect Medical Holdings. I wanted to just I think it's worth making a comment. We've been talking in the series mostly about sort of what's new and different and the way that, privacy has changed in an underlying way. But we got a very good example just in the last couple days and weeks about the way that existing privacy data security threats are out there. And it's really yet another kind of shocking example of how critical the risk is here. We had the 16 hospital Prospect healthcare system, Prospect Medical Holdings, having a ransomware incident that led to outages at least 4 facilities and caused computer systems to be shut down, forcing the hospital to move to paper records, canceling all kinds of services. And so this series, no one should think that this is the entirety of the risks here. We focused on it because it is sort of new and different and evolving quickly. But if anything, this story sort of reinforces yet another example of what a challenging moment this is for everybody, for healthcare providers, traditional healthcare providers, for consumer companies, for the business associates and others who work with them. And it really is just a unique and challenging moment.
We wanted to thank you so much for being with us on this wonderful few-month journey. We hope you'll stick with us and follow Nelson Hardiman for more updates. We're constantly trying to bring you the new information hot off the presses. So thank you again for joining us, and we hope to see you soon.
Thank you so much. Yeah, and we have new content coming. Even I think this week there's going to be something released. So if you're not already signed up for our emails, that's definitely a good place to go. It's a place where we tend to put out information more quickly. But we'd love your feedback. We hope this webinar today and this series has been helpful in kind of charting a course through the evolving new environment. Thank you so much.
Thank you.